right, this one is from Pennington County, South Dakota. If an officer already has developed probable cause and arrested the suspect for DUI, does the officer need to read the suspect Miranda before conducting the standard field sobriety test? Now, this winter, I arrested someone for DUI based on driving behaviors, admissions, and other observations. Because we were in the middle of a blizzard, which fucking North Dakota.
Good on you for making that DUI stop.
Totally. I mean, I would have been like, no. Like, I'm going home, you know?
All right.
So I asked if he would conduct the field sobriety test in a garage at the jail, which is very common, by the way, in these snow countries, which she agreed to. As I see it, because I'm not asking incriminating questions, Miranda is not required. I'm only asking the individual to conduct a standardized series of physical actions that allow me to determine the driver's level of impairment based on observations and so forth. All right. What do you think the answer on that one is, Mark?
Sounds like your cop knows his answer. He sounds like the way he asked his question is very spot on there. So when we look at this, Miranda, arrest light custody, clearly you're under arrest. I'm taking you to another location, known officer. And then now we're talking about imminent incriminating questions. And the way he worded this is a couple of really specific things that are important in here. He talked about observing physical actions to make further determination of the DUI, the impairment. And so when we talk about Miranda, we look at things like it's testimonial evidence. It's what's going on in the old noggin here.
Okay.
So when he's administering these SFSTs, like you said, it's a physical observation, whether they miss the step on the line or the finger to the nose. Got it. Hang on. And all those other tests, but those are things that are observed without getting into the mindset. Now, it takes the mind to do those things, correct?
What do you mean, to do the nose and
right.
do the leg?
It takes your brain processing to do this.
It does.
But when you look at it, it's not testimonial evidence protected by Miranda. So
it makes sense.
So the answer to the question is no, they don't have to read Miranda. But or go.
No. What's your but?
Well, he's going to ask any more questions that takes thought. Hey, how many beers was that again?
Yes.
Or how long were you drinking? Now, those are things that they have to think about, which is testimonial. That's going to be a Miranda, post-Miranda type questioning.
I think you're spot on there, Mike. I think that so Miranda is not required for physical acts. So the field sobriety tests are for physical acts. Hold on, we got okay. So I'm just looking at YouTube real quick. So now let me ask you this. What do you think about the person who is asked to lift up their foot 6 inches above the ground and count to 30? Do you think that the lifting up the foot is Miranda time?
No.
Do you think that the counting is 30 is Miranda time?
No, because it's an evaluation of the physical test. It's not designed to elicit incriminating response. It's giving incriminating answers. Or you're looking at me like I'm crazy.
I'm looking at you like you're crazy.
All right, hang on now.
Think about this.
All right, now I guess you're asking them to think, right? You're asking them to dig into the mindset and deliver thought from the mind. So yeah, there you go. That's Miranda.
So there is a case. There is a case on that, by the way. The 30 seconds was thrown out, but the fact that they kept dropping their foot was in.
All right, but the numerical part.
The numerical part was out because it did have them to calculate time, and that is testimonial.
So this is why you should have not have Face ID password on your cell phone and have still a number password.
Well, what does that mean?
Well, if I just hold your phone up, it'll unlock your phone. You don't have to think about it. But
your
password.
Yes, I see. I see. You're going deep on me. You're going. Yeah. Okay.
just a thought.
All right. So the answer was so far so good. There's Mario and what was it? Shane have some questions I'm going to answer in a second. All right. So are we good here? Did we answer? Let me just make sure.
Here.
Okay, good. No, we're good. Okay.
That one, right?
So let's answer a few things. So first of all, Shane, here's the deal. I'm going to push back a little bit because you said that I don't like Miranda for DWIs. How can an impaired person consent? Let me ask you something. Have you ever arrested people for DUI?
Yes.
A lot of people. I mean, overall, you have a
pretty fair amount.
I've
worked in Las Vegas.
Correct. Have you ever had anybody consent to give blood?
Absolutely.
So they consented to put a needle in their arm. Was that person under the impaired?
Yes.
But you wouldn't have arrested them if they weren't, right?
Correct.
Have you ever, in your experience, and also for my viewers out there, have you ever had this happen to you? Have you ever had a judge tell you, or a DA, tell you that you can't ask a person for consent to put a needle in their arm because they're impaired.
Absolutely not.
There it is.
And the courts and the well, especially the DAs, but the judges, they don't have a lot of favor for self-induced intoxication or altering things and then committing crimes. It's not a get out of jail free
It's not a
card.
get out of jail free card. And Shane, I want you to think about that, right? So whenever you think about a person not able to give up rights because they're intoxicated, well, not putting a needle in your arm is a right, unless you have judicial pre-approval. And no cop on this webinar right now has ever had a judge tell them in open court, you cannot ask a person impaired for permission to put a needle in their arm. So, and also it goes with asking for consent. There are cases out there, Watson is one of them, 1976, where a cop asked a intoxicated, I'm sorry, that was the person who was intoxicated. That person was arrested, maybe a little bit different, but the person was arrested in the back of a police car for consent to search his vehicle, and the cops didn't have probable cause. And the defense was like, well, you can't do that because it's coercive and they're under arrest. And the Supreme Court said, hey, look, it's based on the T to the O to the C.
I love the T to the O to the C.
What does the T to the C mean?
Totality of the circumstances.
So it's based on TOC. So look at the needle in the arm, look at the consent to search with the guy that the lady that left the house, and look at Miranda for DUIs. It's totality of circumstances. And then the other thing I want to, so Shane, excellent point. I'm glad you brought that up so we can talk about it. And I got to give a little props to Mario. Mario says you know because you don't have the three factors: arrest like custody, which you have; imminent interrogation, which you do not have, and for DWIs because you're over for the test, and that for the FSTs, and a known officer.
There you go.